Well,
Okay, so I'll call to order I guess it's a special meeting, but it's the City Council Public Integrity Standing Subcommittee that I'm Councilmember Jeff Kors, Councilmember Lisa Middleton. Thank you for people who are here. This is on the air. There are these new cards you can see. Some people know they're on the air. And so this is the first of what will be quarterly public integrity standing committee meetings to update the public on what we're doing, how the ordinances are working, changes we need to make, and hear from the community about issues that have come up. Do we need to move the agenda officially, or we can just take it out of order because it's a subcommittee?
I'll move it if you want.
No, we'd have to do that. You can't do that? No, you have to hit the button.
Okay.
There you go.
Very good. So it would be appropriate to have a motion and a second, and for the two of you to decide and let the public know what we'll be doing. It's not really a vote so much as just stating what we're doing.
So
orders of the day.
yes, so order of the day is we'll do public comment first. Then we'll do what is now item 3, discussion and update, read public integrity matters. And then after that, we'll do item 2, which is review of the draft public integrity ordinance. So we can get everyone here copies with enough time to look at them as we're going through them. So.
I agree.
Okay. So with that, we'll do public comment, and given the crowd, we normally just sort of will go around, and we don't time people at these. So anyone? And David, it probably makes sense, we will have comment on the items as they come up. So as far as the public integrity ordinance, we will allow more we will have discussion on that. So if those are your comments, why don't we wait till people have it in front of them?
Okay, being thorough, actually, do have a couple of comments on the item 3s.
Yeah, please.
Okay. Good evening, council members. My name is David Friedman. As you know, I served as the co-chair of the Transparency Committee of the Ethics, Transparency, and Governmental Reform Task Force. On item 3D, our committee recommended that a section of the city's website should provide an easy-to-use format, detailed, up-to-date information on transparency and ethics. Among the documents that should be on the website are all FEPC and local public integrity disclosure forms, campaign finance report forms, and certifications of ethics training required under 1234. The city clerk should also upload the public integrity disclosure forms within 2 business days of filing. I filed my form on May 30th, but it has not yet been posted on the city's website. On item 3E, I urge the committee to provide Public Records Act training, particularly on Supreme Court's San Jose decision, holding the communications, conducting city business using personal devices are subject to the act. New policies on this issue recommended by our committee and the ad hoc Ethics, Transparency, and Governmental Reform Subcommittee have yet to be presented to council. Finally, on item 3A, I ask that you establish a regular quarterly meeting date holding special meetings such as today's, limits public comment to matters on the meeting agenda, and our residents should feel free to speak about any issue within the jurisdiction of the subcommittee at its quarterly meetings. To the extent that public comment is not limited to 3 minutes, I wasn't clear, but that can be specified on the agenda. That's it on those items.
Okay. Carl? Russ?
I don't know.
Hit your button so people can hear it.
That's expensive, beating a dead horse. I just want to raise a question about where is my pet toy, the bugle, the whistleblower. I know that the last meeting we had, they corrected some of the stuff, but you were going to seek outside resources to see if we could have it turned over to an outside agency. Can somebody tell me where we stand on that?
That will be in the discussion on the city attorney report.
Oh, okay.
On ethics and transparency. That will be covered in that. And that was written just in response to your comment, David, to keep that open to really anything that people want to, but I think we do need to have sort of a catch-all, because the goal of this is to get public comment on any public integrity related issue. So when we write the agenda, to make that clear.
Can I suggest, I'm Steve Moses, that as Dave did, would you identify yourself as each of us as we speak?
I'm sorry. My name is Russ Youthy.
We are on the air.
And I don't know if I should tell you, I serve on the Ethics Committee as, I guess, chairman now, because the other co-chairman has been gone for the last year and a half.
Okay, thank you. Anything? Okay. So why don't we go in number 3, discussion and update, Republic integrity matters. Main thing I have, because most of it will be in the city attorney's report, in thinking about this is whether it's a whistleblower complaint or an actual complaint that you receive or someone on council receives and refers to you. Often there's personnel information or attorney-client privilege information, but I think it's really important that contemporaneously you keep a record of it, that someone did do a report, what investigation, if any, was done, what conclusions were done, and how it was handled. And that should probably come to the subcommittee in a confidential way, and then we can make an analysis of it. But I think if we don't have a record of those, you know, we will all at some point not be here, and something could come up, and then it's we don't know what happened. So I think just keeping that kind of contemporaneous report, I think would be helpful. So that was my only thing I wanted to suggest.
Eddie, could you review for us what happens when someone makes a whistleblower?
We can't hear it.
Could you review what happens when someone makes a whistleblower complaint? What's the process?
Well, right now, the process is a little bit paused because Mr. Youthie made his comments at the last meeting, and the subcommittee seemed somewhat receptive to the notion of an outside party potentially being responsible for administration of the whistleblower program. So on a certain level, I'm happy to report that we did actually receive our first whistleblower complaint. And I can tell you that it has been sitting just for a short amount of time, pending further subcommittee direction with respect to the process. I concur with Councilmember Coors. It's appropriate and, in fact, in my estimation, necessary to brief the subcommittee on these in an attorney-client privileged manner as soon as they come in, whether it's the city attorney's office that ultimately remains responsible or some third party. There will be, I think, by necessity, a staff report on this when we have data to present to the subcommittee regarding the potential third parties. Commensurate with my other responsibilities to the city, I am right now, it so happens, in the process of compiling a list of 10 attorneys that I'm going to be transmitting to Mr. Friedman for another purpose. Any and all of these attorneys would be equally competent and qualified to administer the whistleblower hotline in the event that the subcommittee wants to make a recommendation to the council in that regard or take action independent of the council in that regard. But Dr. Reddy and I would probably necessarily consult and confer, and he'll make a recommendation to you, I suspect, with regard to staffing and financial impacts of any decision that the council might make to park that program in the lap of someone who will likely charge us well north of $200 per hour, as opposed to it being no cost if the city attorney's office administers the program. And I'm well aware that there are certain things that are worth a price and certain things that are not. But that's why the two of you were elected and why we're providing you with those options. So I expect that at the next subcommittee meeting, we'll be moving forward with a staff report in that respect. And there's only been the one complaint, as I mentioned. Okay. It is, as one of you, I think Councilmember Coors made the comment that these are going to often be personnel-related matters. It is a personnel-related matter.
My experience is there's also firms, in addition to law firms, but outside organizations that specialize in taking over whistleblower responsibilities for collecting the reporting, and I suspect their fees for an all-inclusive program will be significantly less than $200 an hour.
Yeah.
I'm sure that's the case.
I've worked with at least one previously that provided extremely competent service.
And larger cities, just as a matter of course. My very best friend from my mean streets of New Jersey days is currently employed by the city of San Francisco as an employment investigator. So there are plenty of larger organizations that have these independent and trusted employees, and we don't happen to have that. So using a service like what you're describing, Councilmember Middleton, well within the purview of the city council.
But you have to maintain attorney-client privilege.
Oh, yeah.
Which you,
Yeah, of course. But you know, there are other valley cities that already have a whistleblower and they use an outside. It's not much what you're talking about. And we,
Les Sendel. Perhaps my experience with the term whistleblower is unique to hospitals where it's called a compliance officer. And you know, there are various levels of compliance issues, from using the Xerox machine to make personal stuff, to stealing things, to corruption of public officials, et cetera. And I would think that there are some things that should be handled internally, but there may be a threshold where one would want to bring in an outside agency. I'd hate to have every quote, whistleblower thing go to an outside agency when it could very appropriately be handled inside by the city attorney, and it would be up to the city attorney, unless, of course, the city attorney is the subject of the whistleblower, to decide where it goes.
Which is how we initially did it, was as long as it's not the city attorney. But I think the point Russ made, and maybe it is some kind of hybrid, is, you know, here's a normal process on the website, which would go to the city attorney. If you're not comfortable talking to the city attorney, because the city attorney does work for the members of the council, here's an independent, anonymous number you can call to. So
You
maybe
could
there's
even
some kind of
say- You
hybrid.
could even say that if it's a member of city council or the city attorney, it would be sent to an outside
Because if it's a
person.
member of city council, the city attorney is going to send it to someone outside anyway. So I think that might be a way to handle it, you know, some kind of hybrid. The other thing, just because you mentioned it, Eddie, that you sent a list of 10 attorneys to David Friedman on another matter, just to be clear that he's not limited to those 10 attorneys, correct? There's just some ones you know who you happen to let him know.
That's correct.
Yeah.
I'm just doing what I told David
No,
I
no,
would do.
yeah, because I want to be careful that it's anyone who might be a witness has any kind of relationship with. Just from a
No,
transparency point of view, it's important.
the council appointed
Yeah.
Mr. Friedman,
Yeah, yeah.
and it's his decision.
So that was all I just want to check. Thank you. I think we can go to number B. That's you. You're up.
So with respect to our public integrity programs, I'm happy to say that we've had the opportunity through dialogue, Mr. Friedman and I have refined even further beyond the point of the staff report that you're going to be receiving in a few moments, the ordinance and the direction we wanted to go with respect to the ordinance. There certainly are some things that are left right now pending, one being the very good example that Mr. Friedman gave with respect to our documentation and accessibility of documentation regarding public integrity matters. The city attorney section of the website is very, very bare bones. It's a single page if you've ever looked at it, and it simply says it provides a very short description of my job. And it also affords members of the public with a few suggested organizations and I think some contact information regarding ethical issues. That's well short of, I think, what was envisioned by the working groups and the task force and this council subcommittee when you all took up that gauntlet. So it occurs to me that now, with a short break before we have another city council meeting, it's an ideal time for us to start investigating and implementing some of the reforms that Mr. Friedman quite correctly notes have been the subject of ample discussion. I'm not sure, frankly, that the council subcommittee would want them to return to this agenda for even more discussion. That's certainly their decision. I'd like to be presenting what we propose to do to the council subcommittee during the month of August, and either during that month or sometime shortly thereafter, have them provide direction to my department as to how to implement all of those significant evolutions with respect to transparency regarding those forms. City clerk would certainly be a part of that. In terms of the non-legislative portions, because remember, this package here is the second part of a two-part package. That doesn't mean necessarily that the council subcommittee, which is now a standing subcommittee, or that the folks like yourselves who are interested in these issues are necessarily done by a long shot with legislation. There are a total of 6 areas of task force work that really haven't yet evolved into the moment, into the point where we're legislating. So I suspect that this subcommittee and any members of the community who are interested in assisting it will probably move forward and provide direction to my office with respect to other legislation that may be necessary and appropriate. We're certainly ready and willing to accommodate that. I guess last but not least, with respect to public integrity, is the fact that, and I think it's agendized, I'm going to include it, if I may, in the report that I deliver now so as not to speak more than I need to. I want to be clear and be very happy to tell you that the allegations, and there were multiple allegations, that the city misstepped and erred with respect to the Political Reform Act regarding publicity and documentation that was educational on Measure C. Those allegations were simply rejected by the FPPC. I'd also like to note, on behalf of Councilmember Holstich, who's not here today, that there was actually a pair of allegations that she had violated the conflict of interest laws. Those weren't even investigated, so they weren't even deemed by the FPPC to be worthy of that investigation. Dr. Reddy did direct that there be a press release at the time, but in case any of you missed that as an item, I think it's imperative that the folks who are most concerned about the ethics of the city are aware that twice now, since I've been city attorney, the FPPC has cleared the city of any allegation of wrongdoing with respect to educational mailers in the initiative process. I think that really speaks well of our organization and our staff work and the direction that we've received, frankly, from the City Council, which has been really very helpful. We're not the policymakers at the staff level, and they make sure that when we are educating our community, that we're doing so in a fashion that is consistent with the council's take on these issues. And frankly, that is all we can do when we educate. We can provide you with information that we deem reliable, that we hope that the voting community will rely upon. And it gives me real great pleasure to make a report, particularly to this group, that the city was cleared. And I think that's enough for today.
Oh, maybe a little more. So
Any more that you want is fine. I just didn't want
obviously we passed the first ordinance, and among the items in it was that council members, board commissioners had to disclose, one, residents, if they have a lease on a business, other than their residence, but a lease on a business, other things that could be a conflict, and also that rental leases were the same conflict as if you owned. And also, if we had a fiduciary relationship, being a member of a board of directors of a nonprofit organization or another entity, as well as a pro bono lawyer and or accountant financial person, because that's fiduciary. So those should have all been turned in by now, right? I think June 30th was the deadline. So just sort of have people turned those in, and have we notified folks where there are clearly conflicts of people who are serving on boards, commissions, or councils that they can't vote and what they need to do?
I'll have to deliver an update to the subcommittee because I don't have that information readily available. I think that is a great inquiry where we are and where we stand. I can make that information available to you and make it available to the public as directed.
Great, thank you. Go ahead.
A question. Since it has to do with a conflict of interest being direct financial benefit, would being a member of a nonprofit board to which one is not paid or derive any income be a conflict of interest to the new ordinance that you're writing?
No, the one we passed.
The one you passed, I
Yes.
mean.
Yes. So if
So you're going above and beyond
we're going
what
above state law on many things.
I understand.
Yeah. The other thing just to share is that one of the things that's been requested for quite some time is that we not only notify property owners of things that you need to notify under state law within 500 feet sort of radius, but tenants. Because if you live there, it impacts you as much as if you own the property. And we're having some challenge with apartment buildings, how the addresses and how that worked, but that's been worked out. And now we do have a system where we can actually notify people in apartment buildings as well. Because we've had that with street cleaning where people, find they can't get out of their driveway because they're in an apartment building and they didn't get the notice. But we now have, that's gotten fixed at the staff level. They found a way to do that. So I just want to share that with the public. So we now can do that in a much broader way and make sure everyone gets notice within that area. The other two things sort of in this section are city website and potential training sessions. So do you want to touch on those?
We are right now locking in a date to train department heads internally with respect to Public Records Act. I've delivered one ethics training to the community, and I offered at that time and made a commitment that I would provide additional training. Whether it's going to be Mr. King or myself, that's my assistant city attorney, who's a very well-experienced ethics trainer, we're well-positioned to offer that training On an immediate basis, we could probably put something together in the space of a couple of weeks if asked to do so. And we don't presume to schedule these things without direction, so we're looking to you for direction in that respect.
As far as when to schedule?
If it's simply schedule it as soon as possible, we can do that.
As soon as possible.
Then that's what we'll do.
Yeah. And anything on the website other than what's been already discussed?
No, we've not made progress on the website. We have a lot of work to do in that area. And we're hoping to do, as I said, some of that during this period of no council meetings for the remainder of July and August.
Why don't we move to the ordinance? And
Sure.
if you could do sort of a summary of the highlights, so.
Sure.
folks know what
Actually,
they are.
if you write the title correctly, it tells you what's actually going on. That's actually what the Brown Act requires. So we have here an ordinance that amends the existing chapter of the municipal code that we adopted. Again, this is the second half of the package. And we are dealing here with noticing, with lobbying, with applicant disclosure, and we're identifying forthcoming changes in relation to these items. Now, the particulars and the details are obviously considerably more than that. I think it's probably fair to summarize our noticing approach exactly the way that Councilmember Coors did. The notion that you don't have an interest in what's happening around your rented or leased property is a little bit silly. The flip side of that is that as we go through the course and scope of this, we're learning because we're doing things that a lot of government agencies perhaps have not done. So we've decided, just by way of example, with respect to some of the disclosures of rental and leased property, that we're not going to require our commissioners or our board members or our other officials filing these special Palm Springs forms to make specific disclosure of their residence. That is, if you reside in a leased or rented property, you're not going to be held to a higher standard than someone who happens to be lucky enough to own their home. That was under direction and pursuant to direction from the subcommittee, and it certainly makes a lot of sense to me as the city attorney that we wouldn't want to punish somebody who happens to rent or lease with a greater disclosure obligation than the owners. But the noticing provision, as Councilmember Coors says, it really is a very important and quite linked component of this approach to public integrity and noticing and transparency, because at this point we feel like we'll be able to sufficiently augment our process internally to reach everybody. We did need to think a little bit about what we were doing, and I can't promise you that we've nailed it precisely. But by way of example, one of the things that we had to do that's sort of to avoid the law of unintended consequences is when we expanded the group of residents that we would be providing notice to, we had to also expand the number of people that would allow a party providing notice to take publication as a path apart from mailing. So we doubled the number that was in the code in most instances from 500 to 1,000. And I think that's an important evolution because we didn't want to have our greater transparency result in more publication and less noticing. Regarding the lobbying provisions of the ordinance, it's safe to say that most of them have been lifted rather deliberately and with shameless plagiarism from the city of West Hollywood because they had a very, I thought, reasonably simple approach that really did get the job done. That process has been tweaked and has been improved slightly by my drafting, slightly based on input from Mr. Friedman, and I think we've reached a point where I'm happy to tell you lobbyists and their activities will be known, and that'll include not only parties who lobby for third parties, private parties, but also parties who lobby for the city. Registration and transparency are obviously the goals, and this is not a gotcha thing for the city. And I think that probably warrants mention for all of these public integrity ordinances. I don't think that the task force, and I don't think that the council subcommittee was interested in setting up a series of ways to catch people. I think they were interested in setting up a group of sort of aspirations for greater transparency, greater communication, greater disclosure, and higher public integrity. And the goal here, again, not to punish. So we're allowing, just by way of example, in that principle, if a lobbyist hasn't registered appropriately, we're allowing alternate forms of registration. That was one of the smarter things that I saw in the West Hollywood ordinance that I felt was worth adopting and implementing here. There are a host of other things that we have done in here. I think the most noteworthy on a sort of lower level slightly than the two that I just ran down for you is we realized that our staff was having a lot of problems with the business principal disclosure when it came to providing a business principal disclosure in the staff report, because we had written an ordinance that required disclosure down to a threshold of $2,000 worth of ownership. That is an ownership interest of $2,000 or more in value, and that was based on some old regulations that I found very helpful and meaningful. But it occurred to me, and it occurred to the subcommittee, that it would be likely acceptable if we shifted the burden here from our staff with respect to digging in the dirt for people who own $2,000 interests in sometimes quite large companies, and we shifted the burden to the applicant, and we said to the applicant, when you apply to do a project in Palm Springs, it's your job to know whether your owners, whether your managers, whether your directors, whether the people running your company have financial relationships of significance with our officials. And if you have those relationships, you need to disclose those relationships. That's going to actually, I think, conform to what I believe was the purpose of, again, the task force and the subcommittee's work, if I understand it correctly, which was to help our officials to avoid these conflicts rather than to get into a situation where we don't have a practical way to get the work done, or we're not going to meet the council's needs by providing full information.
Can I ask a question on that?
Yes.
Just so I fully understand it. So they only have to provide the individuals who have the ownership interests if they know that there may be a financial relationship with a member of council?
No.
Or they're going to provide all of them and we will see them?
We're still going to be, if the council adopts the version that's here, we're still going to be the beneficiaries and providing disclosure to the council of all of the managers, the directors, the officers and such of any of these corporations. That information is pretty widely available. We can certainly and will certainly ask every time we make these disclosures, we'll ask the people with whom we're speaking, well, who owns the company? But in many instances, what we discovered is that particularly with some of the relatively smaller companies, you had people who had real significant privacy concerns with respect to their investments in these companies that these developers and other parties articulated to my staff. And I will tell you that the concern was not about the identities. The concern was about preserving the confidentiality with which these investments were accumulated. So we took the approach that with respect to disclosure, we weren't going to require disclosure down to that $2,000 level. We were going to simply say that if you have an owner that has a $2,000 interest in the company, that owner or operator make that disclosure. So the council can be certain that you'll have the full disclosure of all of the leaders of the company, the people who run the company, and you'll also have disclosure of ownership to the extent that it's at that macro level, as a matter of course. But what you won't have is a list of 60 or 70 people who own $3,000 interests or $5,000 interests based on the fact.
$10,000 interest. Well, I'm just saying, so someone has that interest and I have a relationship with them. If I don't see that, how do I know if I don't have a conflict, which is the whole purpose of this?
Well, we're requiring them to make that disclosure. And I suppose the direct answer is that you don't know unless the applicants are being truthful. If the applicants are truthful, you know.
Well, no, not necessarily. If the applicants gave us the names and we kept them confidential for privacy reasons and we saw them, then we would know. the person who's applying may not realize that I have a financial relationship with this person, right? So they're being truthful. They don't know that. So we could be voting on conflicts, which actually is not in their interest because they can end up with a 1090 problem and lose all their benefit. So I think we need to see it. I understand their privacy concerns, but council or planning commission or HSPB, people who are making, especially those kind of decisions, need to confidentially see that list in order to know if we have a conflict. Now, the 2,000 level is what you picked, and maybe it's too low, and I'm open to that conversation, but I need to know if, I don't want to vote on something if I don't know that I may have a conflict. And their concern was privacy. It shouldn't be a problem for them to give us that information. Because my understanding, they were all willing to give it, they just didn't want, some of them didn't want it public.
That's exactly correct, and the problem for me is the Public Records Act. If I have that information, I'm not sure exactly that I will be successful in asserting that there's a confidentiality or privacy interest with respect to that information. So it is a difficult problem, and I'm open to any direction the council has. What we have on the books
Right.
was very challenging to implement.
Sure. I appreciate the privacy. Some experience I have with Riverside County Transportation Commission, and there are some very strict rules regarding transportation commissioners voting on any item that they may have a conflict of interest on. It's a section of law that I had no knowledge of before getting involved in with that commission. I bring it up because what happens on the agenda is if there are financial holdings that could create any conflict for anyone, it is identified what all of the financial interests are. It's a part of the agenda. You get your package, and it says, do you have any relationship with the following? And I can break that out and show it to you.
Yeah.
And I frankly think it could be a very good model for commissioners and for city council. You identify it very clearly, and everyone can take a look.
You, the public official, identify it, or you, the applicant, identify it?
What happens is staff identifies for the commissioners
Sure.
and places in the agenda who are the principals behind.
Absolutely, and that's based on an applicant disclosure, I presume.
Exactly.
That's the model we have
Yeah.
in this newly revised ordinance. It's based on the applicants making disclosure of those relationships, but if they lie.
If they lie, then they're at risk.
Right. The bigger issue is that they don't know, right? If you're a 4-person company, you know. If you have 100 investors, you don't know, right? They don't know that, right? Let's just take, you could clearly have a family relationship. You could have a financial interest without knowing. And so I just want to, I think we need to look at this a little more.
I'm happy to look at it as carefully as you're directing. I would just say that the conflict of interest law that we're concerned about violating is at this level, with respect to this issue, if I understand the council's direction, the state law standard. We're not trying to create a higher level of.
I think we were.
Okay, if we
And
were.
I think that was the direction from the task force, was beyond what the state was. So I think we need to just do some more research on this one. And we can talk about it further. This isn't coming back, obviously, until
Yeah,
September
I'll
at the
take
earliest.
any direction. I do want to point out that I'm not sure there is a bright line that's going to make sense on any of this. Because to be blunt, the information we have is only as good as the information we have.
Which leads me to the question of what happens if they make a mistake on their application and they don't list anybody, and there was a conflict of interest as defined under the city's code.
Well, and that's really what I was driving at. Let's say hypothetically, here's the hypothetical to respond, that you have somebody who has an interest worth $5,000 in a very small company that's getting a contract with the city. And that person has some level of financial relationship with one of the officials who's going to be voting. That relationship, 99% for sure, has absolutely no state legal significance. At what level are we going to say it is a material conflict? That's the state law question, how the state law deals with it. Materiality of the relationship. What I tried to do here is reduce the concept of materiality to a manageable, succinct definition. I didn't want to adopt an entire regulatory code like the FPPC has.
Okay, I appreciate that answer, but what I'm trying to figure out is what the consequence is. Because if I know what the consequence is, that may influence at least what my recommendation would be about how the code is then drafted. If the consequences are that the development permit or the ordinance is invalid or void or voidable or subject to legal challenge, as a result, then you might draft your ordinance in one way. If it's not subject to public challenge, because it's a good faith test, unless there's some deliberate misleading, it wouldn't void the ordinance or the permit, then you might draft it another way. So what is the consequence of not doing this? Of making a mistake and not pointing out this material financial relationship between an investor and somebody on the city council?
I may be,
Right.
I tend to believe in not recreating wheels. There must be other jurisdictions that go above and beyond state law that, rather than trying to make it up
Yes.
totally beginning from scratch. So, because others would have experienced this, would have tried different things that were onerous, that didn't work. So is there any way, just like you did with the city of West Hollywood with other things, are there other jurisdictions that have done this, gone above and beyond state law, but made something reasonable?
Right, and that's a suggestion. We just need to go back and do a little research on this before we come to a conclusion.
And we will do that.
Yeah.
And I think the question of the consequences is really the nub of the issue. The other part to me is intent. And where there is an intent to withhold information that someone should have known, and that becomes very difficult to write into an ordinance, but it's what we're trying to get at. Yes,
And,
it does.
you know, as we know, at the state level, with 1090, right, even if the people voting didn't know there was a conflict, and even if the applicant didn't know there's a conflict, the consequences are significant for the applicant, right, if it's material. They lose all benefit of the contract, the city keeps all the benefit, even if it's not with knowledge. So if we're doing it, what we're doing needs to have defined amounts, all those pieces need to be very clearly defined so people know what the rules are.
And all I would say is the nature of the conflict, if we want to assert that it is a conflict at these very low levels of threshold with respect to ownership interest, it's not going to be a 1090. It's going to be a violation of the Palm Springs Code. And in terms of defining that, I think that it's going to be extremely daunting to do something like this, but I will take all the direction and I will certainly investigate all over the state. I will seek.
I noticed in the draft that if you fail to give a notice to everybody, that doesn't necessarily invalidate the subsequent action.
Right. And that's
So
what we
my
need to figure
question,
out.
then the next question would be, so if they failed to do it here, you could build that section into the code too, since it's just the Palm Springs Code.
Right. Correct.
And not subject to state law.
Does that cover our agenda? Yes. Unless you have anything else? Thank you all for coming. David, do you?
Just quickly, the point that I had raised, just to clarify, well, first of all, in my remarks, which I won't bother with, thank you for clarifying the owners versus renters for disclosure of home, because that is an issue that I had raised with you guys a few months ago, so thank you for taking care of that. The rest of it, clearly with the lobbyist, that was part of our recommendation, so thank you again. I think my last comment was particularly working with the sort of the 1PS world, and I can deal with that within 1PS, but the use of the words of directors, board of directors, struck me as being unduly restrictive or leading people to think that if your governing body was not called, which you can be for an unincorporated association, you can call it Board of Advisors, which is the 1PS model, or other things, that it suggests that somehow the use of the word directors limited the disclosure of officials to incorporated entities or unincorporated entities that happen to use that term, and I didn't think that was the intent of so limiting. So I've suggested some language that a nonprofit is independent of its corporate form, just as for the applicants, whether you're a corporation or LLC, you have the same duties. So I've
Yeah.
suggested some language for you guys to think
Okay.
about.
Yeah, and I want to be careful on things like boards of advisors, because often you're on a board of advisors that actually has no fiduciary relationship, all a board of directors does. And we're going to the fiduciary relationship. So I get your point, but we're going to have to be very careful how we word it.
Yeah.
To make sure
Well,
we don't, if someone's on an advisory board but has no fiduciary relationship, that's not what we're going after, right? We're going after the fiduciary, the legal relationship. We don't want, the whole idea is if you have a legal duty to this organization and you have one to the city, you can't serve two masters. If you are an advisor and don't have a legal relationship to the organization and you do to the city, you can.
Well, I mean, so sorry to be picky
Yeah.
about
No,
it. It's the
please.
question of governing board. In other words, if you are on the governing board, my suggestion is that if you're on the governing board, regardless of what it is
Yes.
called. So that was my suggestion. I mean, there could be boards of advisors that are not the governing board. So I suggested some language about governing board,
Right,
or governing body or board.
Yeah.
There's language in the in the
Right.
corporations
Right.
code.
I think
So-
I'm agreeing with you. We just have to be very clear of
Yeah,
who
yeah.
and what we're trying to get
Yeah,
at. That's
and
all.
it's governing
Thank you.
body, because you can have unincorporated 501c3s, 501c4s, et cetera. So I just want to make sure,
501c through even.
yeah.
Yeah.
So anyway, so I suggested some language for you
Great,
guys
thank
to
you.
look at, but I understand where you're trying to get at.
This may be a naive question because I've not had a chance to read this, but can those conflicts of interest be waived? Or once there's a conflict, is it permanently barred?
No, so if you're talking about, if you're on a director,
Once it's disclosed, can it be waived by the city?
no, you can't vote if you have that kind of conflict of interest. Now, if it's in that nonprofit setting, it's a little different. Spouses don't, it doesn't apply to spouses, things like that.
The only instance in which the conflict could be effectively waived is if the board that's voting on the question can't achieve quorum.
Yeah.
In that instance, you draw straws.
Which, under the rule we adopted, we would have had actually on several instances in our grant process before. Okay, well, thank you everyone for coming, and that's it.